you just can't simply bring the evidence in. It has to speak to some matter in the case that's in dispute. And as this case, or as this court established in Prine 1, that this evidence did not speak to a disputed material evidence. The plan or intent or absence of mistake were not disputed material facts.
Mr. Edge, even if we accept your argument on intent and absence of mistake and accident, hasn't the landscape, assuming the application of the amended statute, hasn't the landscape changed on plan?
It has.
What's material
that is correct. There is a specific section of the statute that deals with whether or not something was strikingly similar, as opposed to whether or not there are sufficient similarities to conclude that it was committed by the same person.
Yeah.
Right. And
it was clearly anticipated that would be a lower threshold than the signature that was laid out in Prine, don't you think?
Yes, and I think the statute actually exempts sex crimes cases from that requirement. So I guess the question becomes, does that mean that sex crimes cases still have to meet the strikingly similar standard, or do they have to meet the lower threshold under the statute? And I would suggest that under the plain language of the statute, if you're or exempting it from a lower standard, then you must be using the old standard, strikingly similar.
Or nothing. If you want to take it literally, it says it's admissible. If it's admissible for those sex crimes, just automatically admissible, that would be one reason to exempt it from that standard on plan, because you don't even need to look at plan.
I think that's right. I mean, I think that's the interpretation the state would really like. I think that would not be a correct interpretation, because I think it would simply go too far. And I think, I provided the court with the 609 letter of the Court of Appeals in the Richard Young case. And there the court expressed reservations about having an interpretation of 455 that could simply run roughshod over the weighing of prejudice versus probative value, and how whether or not that would implicate constitutional concerns, specifically the ex post facto clause. And I think it does.
And that very well may be true, but if you just simply look at it, read Prine. Prine says, number one, it wasn't strikingly similar, or that aspect of plan. And the other, that, in sex crimes, propensity can be relevant in the area of pedophilia and that sort of thing. And we invite the legislature to do something. And what they did was, number one, say it is admissible. And number two, here's what we mean, or what should be the test for plan, for being similar. That would indicate they addressed both of those and said it's admissible for propensity. I mean, that was a direct reaction to the invitation.
Well, first of all, I guess I have kind of a problem with the invitation in the first place, in as much as it's citing to, I believe, civil commitment cases. And I think that rather puts the cart before the horse. I mean, in a civil commitment case, you've already established that someone's a pedophile, and you're asking yourself, the court in such a case is asking itself, does this person need to be civilly committed? And that might be relevant under that kind of consideration. Here we're in a criminal case to establish whether or not someone is a pedophile and might later...
I wasn't saying that, speaking to the propriety of that interpretation, but if you look at the invitation and the reaction, it's hard for me not to immediately see that what the legislature was attempting to do was make it admissible for propensity. Now, whether that can be done, but it's hard to look at that opinion and look at the immediate reaction in the law and not say that's what they were after, that's what they were trying to do. Right or wrong, how do we get around that? It's so obvious.
Well, I mean, I guess the problem is that maybe we're a little too inside baseball sometimes. And because we're the players involved, we believe that there's something going on in the plain language of a statute when it may or may not be there. I mean, we have to rely on that. And we can't think that they're speaking to us personally when they pass legislation. Every single member of the legislature requires, I believe, more than 7 votes to get reelected.
You don't think that was Senator Bruce's plan when he wrote the letter saying, here's what Prine did and I want to try to fix it?
I'm sorry?
You don't think that's what Senator Bruce's letter meant when he said, the Kansas Supreme Court recently decided Prine and here's my proposal to fix it? I go back to Justice Johnson's question. Even disregarding all that, had to get around what appears to be plain language of subsection D.
Because I think the plain language says that you have to go, it's admissible for anything for which it is relative and probative. And I think that the case law pretty much establishes that propensity is not one of those things, simply because it is so prejudicial. And what is more,
different.
I mean, there may have been members of the legislature that were listening very closely to the court. There may have been others who voted for other reasons. We have to rely on the plain language of the statute and not what we think they may have been saying to us personally.
But the language doesn't say admissible for material and probative. It says it shall be admissible, period. And then it can be used for any matter for which it's material and probative.
That's correct.
And
Yeah. I mean, there's still a
that's splitting
materiality
hairs,
requirement.
but I mean, the use, the admissibility and the use, it's hard to divorce those. But if you're looking at the plain language to intuit intent, the legislature seemed to separate those two concepts. That hey, it's just admissible, and then it can be used for whatever's material and probative. The language they used.
Mm-hmm. Mm-hmm. Well, I mean, I guess the problem I have is that at the end of the day, you can't make something simply admissible unless there's like some kind of showing of materiality. I don't think any legislature has that sort of ability to tell a court what to do.
Relevance is still the trump, is your point. Relevance, so the materiality and probative value are still a trump.
I'm sorry, could you please speak up?
Are you saying that relevance still trumps? It still has to be relevant to be admissible?
I believe so, Your Honor. Yes. I mean, there's
That
still a
includes
materiality
materiality.
requirement. And in any event, the legislature still, or the statute still references the probative versus prejudicial analysis that has to go on in order for this evidence to be admissible. And I think given that, and given the long history of how courts have said that propensity evidence is inherently extraordinarily prejudicial, that it can't be admitted simply for the purpose of propensity.
Where are you getting the weighing language from the statute? Which part of the statute are you relying on for that? Just so I'm clear.
I think what it says that it says, the court has the discretion to limit the admissibility of any evidence that, I don't have the statute in front of me, I believe that's in 445, that deals with, the court has an inherent discretion to limit the admissibility of evidence when it makes a finding that the prejudicial effect of the evidence would outweigh the probative value
So
of the
you're
evidence.
suggesting we need to look at the two statutes together, not, I thought from what you said you found that language within 455 itself. So.
No. I think that says just subject to these other statutes,
general
and then
statute.
says this about this particular.
Which interestingly, we have interpreted the same way as the federal statute, but that statute does not say the way, frankly, this court's interpreted it for decades. The Kansas statute is worded in a much more narrow fashion than the federal rule. So, I don't know that we want to go there, but
Well, I mean, I think at the end of the day, you have to say that it's not admissible for propensity. All right. I think that you also have to. There's still also a materiality requirement for the admissibility of evidence. So, I mean, I think the reference to 445 simply says that you can't bring it in for propensity. It has to be for some other kind of material fact that's involved in the case.
In this particular case, it was admitted for other things, right? Can we focus on what it was actually admitted for in this case and what the limiting instruction told the jury? And in this case, it wasn't purported not to be admitted for propensity only, correct?
That's correct.
So I want to return to the factors that were actually at issue in this case, if we can.
Okay.
Okay. So if you would just describe for me what your position is on those factors.
I think that there's still a materiality requirement that's inherent in the admissibility of any kind of evidence. And I don't think that the amendment of this, I don't think that the 2009 amendments change 455 in that regard. There still has to be an examination of the evidence to determine whether or not it speaks to a relevant material fact. And this court had already established that that was not the case here.
Except, as Justice Breyer said, the game changed on plan.
You're saying only in non-sex cases, and we should default back to the signature rule in sex cases. Is that your argument?
Yes.
Okay, I just want to make sure I understood it.
Yeah.
Thanks.
I'd like to focus on what impact, if any, you think the legislature's change in subparagraph D to 455 had on criminal defendants. We were talking earlier about, well, it's not for propensity. There still has to be a weighing of probativity versus prejudice. What change, if any, was made to a criminal defendant that would be above that line you've been talking about?
Mm-hmm. You know, I'm not exactly sure. I think that you could read the statute in a way that suggests that there's really no change. I mean, we know that the list of material facts that were in the old 455, plan, mistake, intent, that was not an exclusive list, and so that there were other things that could be brought in. I think you could say that under the new statute, you can use this evidence for any purpose for which it is material and relevant or probative. But that's not really any different than the old 455. I still think that there has to be a materiality analysis and that the contours of that would largely follow the old 455. If it changes that, then I think that you are entering into a place where you have to consider an ex post facto kind of violation. I mean, the rule is that anything that changes or that benefits one party more than the other is something that is an evidentiary rule change that can implicate the ex post facto and those kinds of constitutional concerns.
Is that the test?
And
is that the test, that it's more beneficial to one party than the other?
I think it's the substantial rights. A procedural rule is one that doesn't change the substantial rights of the parties. And
This is a rule of evidence.
in general, rules of evidence apply to both sides equally. However, in this particular case, as the Court of Appeals pointed out in the Young case that I cited, it really only benefits the state. And so the question is, does the additional burden that it puts on the defendant rise to the level of an ex post facto violation? Now, the court didn't get to that point because they had that case was actually tried before the amended statute, and they had remanded it for a new trial at that point. And that's actually on petition for review as well. But so they don't actually reach the constitutional question there, but I would suggest that it is because essentially if we're going to bring in this evidence without any sort of consideration whatsoever, then a defendant is in a much different situation. He not only has to defend himself against the charges, but any number of insinuations that can be brought in as well. And the risk is that even with a proper limiting instruction, we're going to get a jury that will decide to hang the person anyway, simply because he's a really bad person. And And for that reason, I think it sort of implicates the ex post facto clause and that there need to be limitations specifically in order to render the statute constitutional. I think this court could give it the same reading as the old 455, and it would avoid any sort of constitutional infirmities, Your Honor.
Counsel, I see you're out of time. Do we have any further questions of counsel? Do you need about 20 seconds to wrap up, or we'll wait till rebuttal?
Oh, no. I'll sit down, Your Honor.
All right, thank you.
If it pleases the court, my name is Keith Schroeder. I'm the Reno County District Attorney for the 27th Judicial District, state of Kansas, on behalf of the appellee in this matter. I was trial counsel on Prine 1. I was trial counsel on Prine 2, and for what it's worth, on the Young case cited by counsel, I was counsel on that. The Young case, incidentally, the appellate court reversed the conviction in that case, essentially refusing to honor the amendment to KSA 6455 by the legislature. We petitioned the Supreme Court for review. That petition is still pending. That case is not resolved. There's been no mandate issued in that case. The legislature was speaking to Prine when they amended KSA 6455. There's little doubt of that. They acted swiftly. They acted unanimously. Governor Sebelius signed the legislation. All of it happened so quickly, it happened before the mandate was even issued in Prine 1. My respectful request to the court to review that decision. I think the court decided to wait and see how this panned out, I guess, but it was denied. We did a retrial with the same evidence, the court finding it was in fact relevant and probative. It did fit under the statute, that the statute wasn't something that affected substantive rights, but affected the procedure, the analysis by which evidence was determined to be admissible, and therefore was applicable retroactively. The state in its brief goes back past the Civil War, closer to the Revolutionary War, to Calder versus Bull in 1798, listing 4 factors or 4 different ways laws are determined to violate the prohibition of ex post facto. The 4th one, when you look at U.S. Supreme Court decisions, they sometimes indicate that it's dead, but then again, as I indicate in my brief, there's some indication it's still alive. The 4th one talks about laws that alter the rules of evidence and receive less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. What's important about that is the language that says receives less. It doesn't talk about receiving more evidence. In fact, those cases that interpret this Calder versus Bull 4th, I don't know if you call it a 4th prong, but 4th type of evidence, stand for the idea that evidence that altered the legal rules of evidence and required less evidence to obtain conviction are ex post facto. That's not what we're dealing with here. We're dealing with situations, and my brief is full of situations talking about, for example, a person's refusal to submit to a breath test. And the legislature passes a law saying that refusal is inadmissible when it previously, at the time the person was driving under the influence of alcohol or allegedly under the influence of alcohol, they refused to take the test. Now you're admitting more evidence. The fact they had refused, that's been held not to be ex post facto. And that's been held to be that way by the Kansas Supreme Court. Probably the case that is the most on point is a case of 1898 of Thompson versus Missouri. I cite to that on page 27 of my brief. In that case, the defendant was convicted of first-degree murder for killing a priest with poison. During the trial, the court admitted letters that compared his known handwriting to those of the prescriptions used to obtain the poisons. At the time the murder was committed, that evidence was inadmissible as a matter of law, I believe in Missouri. But the Missouri legislature enacted a law that now made those letters admissible after the murder, but before the trial. The U.S. Supreme Court discussed exactly that issue. More evidence is admissible. That does not violate ex post facto. And they specifically said, and I've quoted this on page 28 of my brief, we cannot perceive any ground upon which to hold the statute to be ex post facto, which does nothing more than admit evidence of a particular kind in a criminal case upon an issue of fact which was not admissible under the rules of evidence as enforced by judicial decisions at the time the offense was committed. In many ways, that kind of speaks directly to this case.
Mr. Schroeder, can I move you off ex post facto to what the statute accomplishes?
Yes.
And specifically your opponent's argument that D is to be considered separate from C on plan. I'm most interested in hearing your argument on plan, how that was handled in the second trial, why it comports with the handling or the language of the new statute, of the amended statute.
My interpretation, the way I would urge the court to look at it, is that the amendment to the statute that you see specifically under subsection D specifically says those other issues of intent and absence of mistake and accident plan are no longer the rule that governs the admissibility of sexual misconduct.
But in this case, on the retrial, the evidence of the other crimes was admitted for intent, absence of mistake or accident, and plan. And limiting instruction was given again on those three, correct?
I believe that's correct. And
So
part of that was,
that's the universe we're operating in. I'm just trying to kind of focus back to what happened actually in this retrial, and that's what happened, as I recall.
part of that was just there was no case law to guide us.
Sure.
I understand.
And I understand that.
Yeah.
I'm just trying to figure out whether that was necessary, not necessary in your view. Has the analysis, how does the advent of the new statute, both with C and D, dividing the old statute into A and B, having C on plan, D on sex crimes, how does it affect how the case should be tried? That's what we're trying to figure out.
I think I can answer this.
Okay.
Subsection D specifically talks about evidence of a defendant's commission of another act or offense of sexual misconduct is admissible, which is what Justice Johnson had referred to. There's a comma, and then it says, and may be considered for its bearing on any matter to which it's relevant and probative. And clearly we know what relevant evidence is because we have a statute, KSA 6401 subsection B, that defines what relevant evidence is. I think in determining relevant evidence, the court can rely upon the traditional factors, which is a non-exclusive list, in deciding whether it's relevant or probative. It's not bound by those.
It wasn't even before because
Even
it was
before, because
non-exclusive.
it was non-exclusive,
Right.
but it's something the court can consider. I think the court didn't quite know. We were all kind of, the reference was made to being kind of inside ball players. As trial counsel and trial judges were so used to the rulings of the court determining the admissibility of 6455 that when there was this change suddenly to the statute, how do we apply that with the limiting instructions that the PIC gave us and the purpose? Does it come in as just clearly propensity, or does it have to come in for some other purpose?
Well, here it came in for the three purposes. The jury was told that.
Yes.
Okay, so that's our universe. That's where we're operating here. So I want to understand what your position is on what the standard is on plan in a sex case under the new statute. Because your opponent took the position that because D is a standalone, which frankly is the argument being made by the state in some of our other cases this morning, as you're probably aware, that because D is a standalone on sex cases, that C does not apply on plan, and his position is that you therefore have to default to the rule of Prine on signature. And so I'd like you to address that.
I think subsection D and the amendment supersedes the subsection C, makes it more something the court can look at as far as relevancy or probative value.
So D and C are to be read together on plan, in your view?
Well,
is that consistent?
no, I think D is to be read alone by itself.
Okay, so that's what I'm asking.
Yes, and it makes it admissible. But when you're looking at those issues in D that talk about relevancy and probative value, the court can look at some of the traditional factors that are used under 6455.
I understand that much. So plan is one of them.
Yes.
And plan is one of the ones that was afoot in this case.
Yes.
But what is the standard for plan under the new statute for
I believe
a
it would
sex
be-
case?
I would believe whether it's relevant or probative.
So
Okay.
there needs to be nothing about so similar or strikingly similar. D just wipes all that out, and we're just basically saying if you're talking about a sex offense, a prior sex offense, or other sexual misconduct is admissible, comma, as long as it's relevant and probative.
Yes. And I think that's exactly what the legislature intended on doing when they enacted this statute, was to change the standard by which this evidence would be admissible in these particular cases.
And excuse me a minute, in your opponent's position that, well, that may be what D says, but this court has held that propensity evidence is, by definition, not relevant. So he doesn't feel that evidence being admitted under D can be brought in for propensity. And my understanding is that either you or some of your fellow prosecutors this morning are arguing, no, that's why it's in here.
Yes.
And that's your position?
Yes.
Okay.
But
I'm
in
sorry,
this case, it wasn't brought in for propensity. It was brought in for intent, absence of mistake or accident, and plan.
It was, but
In this case,
I'm
that's
gonna,
what
I'm
the
going to
jury-
do the fallback of saying that if a court makes a decision for the wrong reason, but it's the right reason, then the court's
I cut
reason
you
for
off,
doing
I'm
that.
sorry.
But
No,
wasn't
no,
this-
that gets us right in. I just wanted to address that plan doesn't really apply. It's relevant and probative, or similarity doesn't apply. Isn't that how we got to similarity? That originally plan was, hey, if this is part of the overall plan where you're planning this crime, and then it sort of morphed into, well, modus operandi, or it's so similar that it's a signature, and that was a function of the relevance and materiality that we came up with the similarity, and the strikingly similar or just similar was what tests we used to determine whether it fit within the plan. So how can you say that just because it says probative and material, that changed that similarity plan or similarity test when that was why it was developed?
And if I can tag on to that before you answer, because it's just a tag on, even if it's not material, those cases talked about the probativeness of the.
I guess the best way I can answer is that when the court was making these earlier decisions that morphed to the strikingly similar, and in the dissenting opinion of State versus Prine, Justice McFarland discussed that in detail, and in her belief that the court had misinterpreted some of those cases, and that the term strikingly similar was just a term used by the court in another case to describe the evidence in that case. It wasn't intended to be something relied upon by future cases. But those cases were based upon the interpretation of the statute that existed, KSA 6455, which has already been acknowledged as being much more restrictive than Federal Rules of Evidence 413. The federal rule is much more expansive, and allowed in propensity evidence has been held to be constitutional. And so this was an effort by the legislature to, in fact, say we're going to move away from the strictness of 6455 in these type of cases and move towards the federal rules. The new amendment is essentially mirrors Federal Rule 413 and encompasses language from Justice McFarland in the dissenting opinion of Prine.
And why was it probative and material then? I mean, just don't put the label plan on it. Just tell me why it made a difference.
He had previously, in this particular case, he gave 3 justifications for touching the child that he claimed were innocent. One was the child that slid down his arm in the swimming pool. One was wrestling. One was watching pornographic things on a computer, and she walked in and he licked his fingers to wipe something off of her face.
That goes to intent and absence of mistake or accident. How does it go to plan?
But now going to the probativeness, you're dealing with a child that was 6 years old. The 2 prior children were 6 years old, or were in that age group or so. The court in Prine 1 focused more on in my opinion, more on the differences than some of the similarities. I had argued more of the similarities, and that was detailed. The licking of the fingers before the fondling, the rubbing nature of what happened. We think those things in and of themselves, the age group, the similarity in the sexual contact, clearly met the issue of whether it was relevant.
Well, and what I'm hearing you say is that it's relevant because of those similarities make it appear that this is his signature method of doing this. I mean, how do you jump from he did that, it was all similar, to that it's relevant and probative here, unless you say that was the modus operandi or that was the signature way you did it? I mean, the only way that connects is because you're looking at how the prior was done to say, well, it must have been the same person that did this.
I think the burden is much different. It's not a strikingly similar thing. The fact that in this case, I've argued from the beginning it was strikingly similar, doesn't change the way that this new amendment should be interpreted. This new amendment would apply to cases in which there are not strikingly similar acts. We think it applies to other sex cases, and that's what the statute specifically reads, is that the defendant's commission of another act or offense of sexual misconduct is admissible. If this were in fact a DUI case, and we sought to introduce evidence that the defendant had previously been convicted of aggravated indecent liberties with a child, clearly that wouldn't be relevant. If it were an aggravated robbery case, clearly that wouldn't be relevant. What was relevant is it involved the alleged sexual abuse of a 6-year-old child, and he had previously done that before, and we believe, based on the amendment of the statute, it was relevant, it was probative.
I understand that is what you believe the legislature intended to do. I'm not sure there's really any serious question about that. But I think there is a serious question about whether the legislature accomplished what they intended to do. And that is how, as long as Prine 1 majority said to be probative and material, the plan has to be strikingly similar, how this legislative amendment overruled that majority decision. I mean, in answer to the previous question, you pointed to the dissent, but that was the dissent. The majority said, I think, fairly clearly, that was the test to prove probativeness and relevancy.
And the amendment of the statute was the legislature's way of stating we're going to change the admissibility standards or analysis to say that evidence of this type is admissible in all cases where it's found relevant and probative involving sexual misconduct.
It definitely succeeded in changing the plan landscape on non-sex cases, because that's subsection C, right?
Okay.
That's how you read C, correct? To apply to non-sex cases. Well, I beg your pardon.
I'm not sure how
Some
you
of your
should
fellow
answer that.
prosecutors, I believe, will be arguing that later today, that C is a non-sex case section and that D stands alone on sex cases.
I would agree with that.
Okay, all right. I would say it in the reverse way makes it easier for you. The bottom line is that the legislature said very clearly in C, we are adopting the dissent position, and
Yes.
to the extent the common law has been otherwise, we are changing it.
And we're going to admit propensity evidence in cases involving sexual misconduct.
That's D.
You think that's what
That's
D
D,
says?
yes.
But propensity is not what it got admitted for here. It got admitted for plan. And
I
that's
agree.
why we just keep going back to that. How do we figure out what plan means in sex cases under D if C does not apply?
I don't think you have to prove one of these other issues. I think the court can rely upon.
But that's what
plan.
happened in this case. That's the reason we're struggling. And I understand your fallback is if we messed it up, it's a propensity, and propensity's cool under D. I understand that's your fallback. I'm just trying to see. I'm trying to distinguish what plan means in sex cases post amendment under D. And
I think-
when we asked you, you said, "Well, it's similar in these ways." I
Well,
mean, that's what you
in this particular
answered.
case, when I'm asked how is it relevant and probative, I could say it's relevant and probative because he sexually is alleged to have sexually molested a 6-year-old child, and he had previously done it twice before to 2 other children.
Same
End
age.
of it. But the facts of this case are stronger than that on the relevancy. So I throw that in there, not to say that there should be some elevated standard on relevancy and probative value of other crimes evidence, but in this case it was stronger. It was stronger than just, it far exceeded that threshold for relevancy and probative value. We think it was relevant and probative. It met the statute. We think it's retroactive. It applied to this case. It was enacted for this case. We ask that you uphold the will of the legislature and affirm this case.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
You had reserved 3 minutes.
Thank you, Your Honor. I would just like to make 2 points regarding plan. First of all, if we want to go with the state's interpretation, then there's really no rule left for what kind of things can be admitted to prove plan. You wouldn't even need to prove any similarity between the acts, nor would you even need to prove or have a reasonable certainty that they were committed by the defendant. And that's just simply a kind of absurd reading. It's pretty broad.
Well, isn't that,
Well,
isn't that exactly what the legislature appears to have intended, which is to say it's relevant to show propensity in sex crime cases?
no, I think what they've done is that they've lowered the standard, but they've retained it for sex crimes cases. And
What
the
makes
reason I
you
say
think
that is I
they've
point to
retained
subsection F of the statute, where it says, this rule shall not be construed to limit the admission or consideration of evidence under any other rule, or limit the admissibility of evidence or crimes or civil wrongs into criminal action under a statute other than in Articles 34, 35, or 36 of Chapter 21 of the Kansas statutes annotated, et cetera, et cetera. So in other words, those same categories of crimes that we're talking about as the exceptions in the plan requirements and the general 455 requirements, under subsection F, we're saying, well, we're not going to interpret this rule to limit the admission of evidence in a criminal case except when these kinds of statutes are involved, when these kinds of crimes are involved. And I think that leads to an interpretation of the plan requirement that says that we're not simply dispensing with any requirement whatsoever for admissibility with regard to plan. I think the way that the plain language of the statute is tumbled out, regardless of whatever various legislators may have said, is that we're at a point where strikingly similar is gone for everything except sex crimes. So, if there are no further questions, I'll yield my remaining time to the
I just
court.
have one quick one just to make sure I'm clear on something. Your opposing counsel suggested that his fallback is propensity can come in. So if there was an error here, the district court was right for the wrong reason. You haven't made a constitutional challenge in this case to the use of this evidence for propensity only, have you?
I mean, I think if we're going to allow it for propensity only, then I think that the ex post facto analysis is triggered.
Okay.
Because I
You've
think
made an ex post facto challenge, but you haven't made a due process challenge to propensity evidence generally.
I think I may have mentioned a due process challenge, but it was
Okay.
But I haven't briefed that as a separate issue, Your Honor.
Okay, thanks.
There's 2 kinds of plan, where it's part of the plan to commit this crime. And then the one we've developed that's basically, it's similar or it's a modus operandi. And that part of the plan looks a lot like propensity, doesn't it? That, hey, these others, children were 6-year-olds and all this was done this way. So it looks like this person has a propensity to do this with victims. And so if propensity is an allowable reason to admit it, then maybe plan is. Maybe that first point you were making is true. You don't have to jump through any hoops for our court-created prong of plan. You just prove propensity. You follow what I'm saying?
Yeah.
Maybe that was the intent of the legislature. Yeah, the plan doesn't apply, or that type of plan analysis doesn't apply to sex crimes anymore because you can get it in for propensity, so you don't need to try to backdoor it by saying it's the MO of this person.
Mm-hmm. Well, first of all, I would say that if you're going to allow it that way, then there are constitutional implications to that interpretation of the statute.
I understand that.
But consequently, because of the court's duty to interpret statutes in a way that renders them constitutional, we have to impute that the legislature did not intend to violate the Constitution in such a way. But I guess in a deeper sense, I mean, I'm not really buying the premise that plan is just, or that propensity is just watered down plan. Because the kinds of evidence that we use to prove propensity is a lot more inclusive, much broader universe of kinds of allegations than there were these discrete acts that were committed on particular occasions, and they had factors which are similar to the present crime. Propensity is simply things like, he has a bad character, or, he ogles little girls in the park, or something like that. I guess if you could say that if it's related to plan, that it's sort of like I guess you would say a homeopathic preparation of plan. It has 1/1000th of a part of plan in it. So if there are no further questions from the court, I'll yield my remaining time.
Any more questions of counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.